Hello, everyone, and welcome. I am Jeremy Morris. I am an April board member and the facilitator of this workshop today. Thank you for joining us for the ADA Addiction and Recovery. I want to mention a few housekeeping items before we get started today. First, when you scroll over the screen, a menu pops up. Depending on what device you are on, in that menu, you can find it at the top or bottom of your screen. That's where you will find the closed captioning for today's session. You can view the captioning by selecting the CC tab on the menu bar. For sign language interpreting, you can find the interpreter on the screen. If you would like to change the size of the screen, if the slides are shown, you can select the line in the middle to make the slides larger or smaller. For Spanish interpretation, you will find the globe icon on the menu bar. Please select on the interpretation button. You can then select on Spanish. If you want to hear Spanish only, select mute original audio. If you have technical issues, please use the chat feature. You can find the word bubble in the same menu bar. If you would like to turn the chat feature off, if you're using a screen reader, you can do that by pressing Alt-H, or please use the info and help section on the conference website for more help. Today's session will run pretty much to the very end of the time period, so we may not get a chance for live question and answer. So we encourage you to include all questions you have in the Q&A box in the menu bar. As you submit questions or make comments, we will record all of those and give those to Barry, our presenter today, so that he has the time to answer them, and they will be posted later on the April website. So if we do have time, we will go through those logistics at the end. At the end of the session today, please take time to complete the evaluation when the webinar closes. That helps us know so that we can keep improving this conference and provide trainings that are most useful to you. Thank you all for joining us, and don't forget, if you are registered for the youth conference, to join after these sessions tonight. We hope that everyone will be able to join us again starting tomorrow. So with that, I will pass this off to Barry Whaley to get the presentation started.
Great. Thank you, Jeremy. I appreciate it. Hi, everybody. Good afternoon. Very sorry we are not in person, but happy to be with you, at least virtually. I'm Barry Whaley. I'm the director of the Southeast ADA Center. The Southeast ADA Center is one of 10 centers that make up the ADA National Network. Southeast ADA Center is a project of the Burton Blatt Institute at Syracuse University. Quick disclaimer, Southeast ADA Center and the other centers are funded by NIDILR. It's the National Institute on Disability, Independent Living and Rehabilitation Research. Within the ACL Administration for Community Living, Department of Health and Human Services. Two things for you to remember. Number one is the ADA centers exist to provide informal guidance on the Americans with Disabilities Act and associated disability rights laws. We cannot provide a legal opinion as to your rights and responsibilities under the law. We can only provide that informal guidance. The other thing to remember is that the Southeast ADA Center is not an enforcement agency of the ADA. So today what we're going to talk about is the ADA addiction and recovery and how the law applies to those people in addiction, who have experienced addiction. So first, we're going to define disability as it applies to alcohol and drug use disorders, substance abuse disorders, and opioid use disorders. We will also talk about what obligations employers have under Title I of the Americans with Disabilities Act. And then we'll also talk about what are the obligation that employees who are experiencing substance abuse disorder, what obligations they have under the law. So the Southeast ADA Center, I've already said, is funded by NIDLR. This is our telephone number. It's 1-800-949-4232, 1-800-949-4232. So if you have any question about the Americans with Disabilities Act or other disability rights laws, you can call that number and talk to one of our technical staff to understand your rights and responsibilities. You can also email us at adasoutheast@syr.edu, as well as there's our web address, adasoutheast.org. We are Region 4. We serve an area from Kentucky to Florida, from Mississippi to the Carolinas. So let's begin by looking at some numbers. So there have been some changes since 2018. Certainly the pandemic has had a major effect on that. 57.8 million adults either had substance abuse disorder or mental health diagnoses in 2020. And that's the number from 2018. By 2020, we see 73.8 million adults either had substance abuse or mental health disorders. The yellow ball represents 10.2 million people who had a substance abuse disorder but did not identify as having mental illness. And in 2020, so 10.2 in 2018, by 2020, this is more than doubled to 20.9 million people. The blue ball, in 2018, 38.4 million people had a mental illness diagnosis, but not substance abuse disorder. By 2020, we see a slightly reduced number of only 35.9 people who identified as having a mental illness, but not substance abuse disorder. The green area in the middle represent 9.2 million people who had substance abuse and mental health disorder in 2018, and that number by 2020 has risen to 17.0. So you can see that those numbers almost double, and certainly the impact of the pandemic has had impact on these numbers. So the pandemic has led to sharp increases in alcohol and substance abuse disorders in the United States, as well as in behavioral health disorders. Interestingly, more than 70% of people who identify as using alcohol or drugs or illegal drugs continue to maintain employment. There was a study recently conducted by the American Addiction Center that found that 1 in 3 Americans were drinking alcohol during work hours while on lockdown or working from home. Over 22 million people are currently in recovery from alcohol and other drug use disorders. And although addiction affects all demographic groups, drug and alcohol abuse among African American communities is slightly higher than the general population, with rates of substance abuse at 6.9 for African American populations compared to 7.4 for the total population. And according to a 2020 survey on drug use and health, 44.7 of adult African Americans reported illicit drug use in the past year. American Indians and Alaska Natives have some of the highest rates of substance abuse, with 22% reporting using illegal drugs, 5% reporting heavy alcohol use. So how does the ADA apply to alcohol and substance abuse disorders? So we have to understand first what the ADA is. It is a law to ensure that people with disabilities have the same rights and opportunities as anybody else, and that includes people with addiction to alcohol or people who are in recovery from opioid or substance abuse disorders. You know, the ADA is a sweeping civil rights legislation. It's signed into law in 1990, preventing discrimination against people with disabilities in all aspects of life, including work, education, transportation, public and private places where the public go to access goods and services. And the law ensures that people with disabilities have the same rights and opportunities as anybody else. We have to remember that under the ADA, disability is defined as a legal term and not a medical term. And in a moment, we're going to talk about the 3 ways that someone might have protection under the law. So in this picture, here is a picture of the signing of the ADA. It's a beautiful summer day, July 26, 1990. The fellow to President Bush's right is Evan Kemp, who at the time was the director of the EEOC. Behind him is the Reverend Harold Wilkie. To Bush's left, over his shoulder, we see Sandra Perino, who at the time was the director of the National Council on Disabilities. And then, of course, the guy in the cowboy hat to Bush's left, the father of the ADA, that's Justin Dart. So it's customary at the signing of a major piece of legislation that the president will give out ceremonial pens to people on the stage with him. And interestingly, Reverend Wilkie is born without arms, and in a sublime moment of disability rights, he accepts his pen from the president with his left foot. Here's a picture of him accepting his pen. So when the general public thinks about the ADA, they typically think about what? Accessible parking places or an accessible bathroom. But really there are 5 titles to the law. Title I are the employment protections. This allows people with disabilities to have access to reasonable accommodations to provide equality in the workplace. Title II are public entities and transportation. So this is state and local governments. Title III are those places of public accommodation and commercial facilities, stores, restaurants, banks, movie theaters, doctors' offices, arenas, any place where the public goes to access goods and services. Title IV are the telecommunications provisions that allow for captioning on our televisions or, other ways that people who are deaf or hard of hearing or have communication difficulties so they can communicate effectively. And then Title V are the technical provisions of the law. Since we're talking about substance abuse disorders today, it's reported that 10 to 25% of American population is sometimes on the job under the influence of alcohol or illegal drugs. And the social and economic costs of substance abuse in America are just staggering. So under the law, there are 3 ways that disability can be defined. The first is that someone has a physical or mental impairment that would substantially limit one or more major life activities. In this case, addiction can substantially limit brain and neurologic functions, the ability to work, our ability to learn. Addiction can also interfere with sleeping or eating, concentrating, caring for ourselves, memory. Each of these are considered a major life activity. But you could also have a history or a record of having a physical or mental impairment that substantially limits one or more major life activities. So perhaps someone has successfully completed an alcohol or substance abuse recovery program, and they are no longer actively using drugs illegally. They may still have protection under the ADA because they have a record of having that disability. Then third, someone might be regarded as having the disability. And in this third prong of disability determination, an employer might hear a rumor or have an assumption that an employee has an addiction, and based upon that belief, without any substantive proof, may take a negative employment action against that employee. In that case, that employer has regarded that person as having a disability, and then that employee then might have protection under the law. As I mentioned, addiction is an impairment that substantially limits these areas of major life activity: brain and neurologic function, working, learning, sleeping, eating, concentrating, caring for yourself, remembering. And this is a very complicated and very complex topic. So here's one of the first areas where it becomes a little complex, is that the ADA makes a distinction between alcohol addiction and the illegal use of drugs. Looking at the illegal use of drugs first, an alcohol or an individual who is using drugs illegally is not considered to have a disability, and an employer could take an employment action based on that illegal drug use. Individuals then do have protection if they enter a recovery program or are no longer using drugs illegally. So in recovery means that the individual is no longer engaging in using drugs illegally, or they are participating in a supervised rehabilitation program. And that term illegal drug use includes the use of illegal drugs such as heroin or cocaine, but it might also include the misuse of other controlled substances like opioids or morphine. And that's regardless if the user has no prescription or has a fraudulent prescription or has a prescription but is using more than the prescribed amount. Now, under the ADA, alcohol addiction is generally considered to be a disability, whether the addiction occurred in the past or it is in the present. An individual with alcohol addiction has immediate protection under the ADA. And there are several court cases that have ruled in favor of this immediate protection. One is Williams versus Wendell out of the 10th Circuit in 1996 that upheld that alcoholism was a covered disability under the ADA. That is reinforced by Adamczyk versus Baltimore County in 1998 out of the 4th Circuit, Miners versus Cargill Communications in the 8th Circuit in 1997. And then also we look at the Office of the Sergeant at Arms versus the Office of Senate Fair Employment Practices from the Federal Circuit in 1996. However, we need to keep in mind that other circuits are reluctant to designate alcoholism as a covered disability, and they urge a case-by-case evaluation to determine the existence of a major life impairment being impacted by the alcoholism. Court cases to reference there out of the 5th Circuit: Birch versus Coca-Cola in 1997, Wallen versus the Minnesota Department of Corrections in 1998. So when I say recovery, what do I mean? Well, the ADA protects someone who is in recovery and no longer engaging in the illegal use of drugs. You know, an individual who is using drugs illegally, again, is not considered to have a disability if an employer takes an employment action based on that drug use, because employers also have what's called a duty of care to have a safe workplace for all of their employees. Individuals do have ADA protection if they enter a recovery program and no longer use drugs illegally. And in recovery means that the individual is no longer engaging in using drugs illegally, or the individuals in a supervised rehabilitation program. So only people in recovery are considered to be someone with a disability under the law. So what do we mean by that? Well, a person is in recovery from substance abuse or substance use disorder and is no longer engaging in the illegal use of drugs, or they are in that supervised rehabilitation program. So what do we mean by illegal use of drugs? So illegal use of drugs such as heroin or cocaine or opioids or morphine, and we've already talked about this, they may have a prescription, they may have a fraudulent prescription, they may be using more than the prescribed amount. So what do we mean by current? Because the law says current use of illegal drugs. So what do we mean? The EEOC offers us this guidance. If an individual tests positive on a drug test, he or she is considered a current drug user so long as the test is accurate. By current, we mean that the illegal use of drugs was recent enough to form a reasonable belief that someone's drug use is a current problem and presents an ongoing problem. The EEOC further says that current isn't limited to the day of use or recent weeks or days, that it has to be determined on a case-by-case basis. And there are a couple of court cases too that illustrate this. One is Zenor versus El Paso Healthcare out of the Fifth Circuit, where the Fifth Circuit held that a pharmacist who is an employee of El Paso Healthcare was a current user of illegal drugs because he had used cocaine within 5 weeks before he was notified of his termination. We also look to a court case out of the Third Circuit, Sally versus Circuit City Stores, where here the court remarked that it knew of no case where a 3-week period of abstinence would be considered a long enough period of time for someone to no longer be considered an illegal drug user. Finally, in Schaefer versus Preston Memorial Hospital, 1997 out of the Fourth Circuit, Schaefer had appealed a lower court ruling that ruled in her employer's favor. It was Preston Memorial Hospital, and she was claiming disability discrimination due to her drug addiction. She'd been stealing fentanyl, which is Schedule I narcotic, from the hospital, and she became addicted. She entered a rehabilitation program, but was terminated for gross misconduct involving the diversion of controlled substance. A few weeks after her termination, she went to work at another hospital where she again stole fentanyl and used it while on duty. And in this case, on appeal, the court ruled that Schaefer could offer no credible evidence that her termination was the result of disability discrimination, but rather it was the result of not following hospital policy. So let's turn our attention to Title I, the employment protections. So does the ADA apply to all employers? No. Private employers with 15 or more employees or all state and local government employers have to comply with the ADA. A private employer with 14 or fewer employees does not need to comply with the ADA. Excuse me. And this applies to all aspects of employment. Job applications, interviewing, job training, benefits or conditions of employment are included. Now, under Title I, an employee is considered a qualified person if he or she can meet the skills, the experience, the education, or the other job-related requirements of a held or desired position, and they can perform the essential functions of a job with or without a reasonable accommodation to how the work is performed. We need to keep in mind that there are 3 stages of employment, and the ADA addresses addiction and recovery differently in each of those stages. So stage 1 is pre-employment, pre-offer. Stage 2 is pre-employment, post-offer. So an offer of employment has been made in stage 2, but the employee has not started work yet. Then stage 3 is on the job. So in phase 1, or stage 1, pre-employment, pre-offer, the ADA prohibits all disability-related questions and medical examinations, even if they relate to the job. Asking disability-related questions in this stage of employment may reveal a disability that someone does not want to disclose. So in stage 1, what employers cannot ask? Well, they can't ask if you're taking prescription drugs. They can't ask if you have a disability, an illness, or a condition that would prevent you from doing the job. They can't ask you if you've ever been treated for alcohol, opioids, or other drugs. So we need to keep that in mind. This is pre-employment, pre-offer. Often in this first stage of employment, if someone has experienced substance abuse disorder or has experienced alcohol addiction, they may have gaps in their work history. So the question often comes up, does the job applicant have to mention their addiction? Well, it depends. So an applicant, what's a good way to address this? An applicant could say that maybe he or she has had an illness, they've recovered, they're excited to get back to work. However, if the employer were to ask specific questions about that her disability and could reveal an addiction, what should you do? Well, you should tell the truth, even if that question is illegal, because if you don't tell the truth, the employer would consider you to be lying, and that might not be a cause for hiring. However, we need to keep in mind that an employer, again, asking those questions at this stage of employment is an illegal question, and you certainly would have protection under the law if that employer asked those questions. So what can an employer ask? Well, they can ask about alcohol or illegal drug use in a general way. They can say, have you ever used or do you currently use? Because answering that question wouldn't result in revealing a disability. Now, they can ask that general question, but they can't ask to the extent or the frequency of drug use. That's illegal. They can't ask how much alcohol or drugs do you or did you consume. They cannot ask how often do you or did you drink alcohol or use illegal drugs, because this may reveal a disability. Now, stage 2 is pre-employment, post-offer. At this stage of employment, an offer of employment has been made, the candidate hasn't started work. An employer can legally make medical inquiries. They can require medical exams, and they can ask about disability-related questions. But you need to keep in mind is that these questions must be asked of all candidates within the job category. So in this stage, employers may ask about the use of alcohol or drugs and the extent of use, or if the candidate has alcohol or drug addiction. And you would be required then to disclose that disability at this stage if asked. Now, we need to keep in mind, again, this is a very complex topic. And we need to keep in mind that this is a topic that has been exacerbated by a worldwide pandemic. So in the midst of a global labor shortage, employers, we're finding many are doing away with drug tests in a desperate bid to attract more applicants and to fill jobs and retain more workers. There was a study done by Manpower Group that was released earlier this year that indicated that 9%, I'm sorry, not this year, last year, that 9% of more than 45,000 employers worldwide were eliminating job screening or drug tests as an incentive to attract and retain in-demand talent. That equates to about 4,000 employers in 43 countries who are willing to turn a blind eye to a worker's recreational drug use if it means filling a vacant position. Also, in June of last year, Amazon, the second largest global employer, announced they would no longer test for marijuana or cannabis in their pre-employment drug testing unless it was a job that was regulated by the US Department of Transportation. Amazon believed that by not testing for recreational cannabis use, they could increase job applications by 400% according to a Bloomberg report. That they also believe the company believed that if they screened for marijuana use, that would cut the prospective worker pool by up to 30%. So the third stage of employment is on the job. Now, on the job, an employer can make disability-related inquiries and require medical examinations only if they are job-related and are consistent with the business necessity. So what does that mean? Well, in regard to substance abuse disorders or alcohol use disorders, if an employer has a reasonable belief based on objective evidence that somebody's ability to perform the essential functions of the job would be impaired by a medical condition, or an employee's medical condition could result in a direct threat to themselves, their coworkers, or to the general public. So remember that duty of care that employers have. So employers can ask if you've been drinking alcohol or if you are using illegal drugs. However, an employer can't ask about the nature or the severity of that employee's disability, or ask about someone's genetic information as well, because that is also protected not only under the ADA, but also, under GINA. Because employers have a right for a safe and drug-free workplace. Now, stage 3, there are some allowable questions. You can ask about your employee's well-being. You can ask about non-disability related impairments. And you can ask about that employee's ability to perform essential job functions. You know, if an individual who has alcoholism is often late to work or unable to perform the responsibilities of their job, an employer has a right to take disciplinary action against that person on the basis of poor job performance and conduct. However, an employer may not discipline an alcoholic employee more severely than it does any other employee for the same performance or conduct. Under stage 3, an employer can ask if you've been drinking or if you're currently using illegal drugs. They can get contact information for someone to contact in an emergency. They can't ask about, again, the nature or the severity of the employee's disability. They can't go to another person and ask about the employee's disability. And again, I've already mentioned that they cannot ask about genetic information that's protected under ADA and GINA. GINA is the Genetic Information Non-Discrimination Act. Also, an employee or an employer cannot ask about an employee's prior worker compensation history. So let's look at some scenarios. And this is difficult since we are virtual, but let's try to work through these. So here we have scenario 1. Mariana is a former heroin user. She has been heroin free for 6 years. She applies for a job that she is qualified to do. In this case, the employer refuses to hire her because that employer learned about her past addiction. Does Mariana have protection under the ADA? Well, yes, Mariana is protected because, remember, there are those 3 prongs of disability determination. And the second prong is having a history of an impairment. So Mariana has a history of an impairment, in this case, addicted to heroin. She has refrained from using illegal drugs for 6 years, which in an individual assessment is a pretty good indication that there is not an ongoing problem with drug use. So an employer, by not hiring Mariana, violates the ADA by refusing to hire her. Here's another scenario. So here's Michael. He's often late to work. His supervisor asks or warns him about his lateness. The 3rd time Michael is late, his employer gives him a written warning, stating that one more late arrival will result in termination. Michael discloses to his supervisor that he's addicted to alcohol and that he's often late due to his drinking. And he requests immediate time off for detox and treatment. And under this scenario, does Michael have protection under the ADA? Well, Michael does have protection because he is a person with a disability, alcohol addiction. We need to keep in mind that alcohol addiction could be in the past or the present. We need to keep in mind, though, that this disciplinary actions taken against Michael prior to the disclosure of his disability stand. They don't go away. That warning that he would be terminated again still stands. The employer can require an employee with addiction to alcohol to meet that same standard of performance as behavior as any other employee. And this is true of any sort of reasonable accommodation. So if you have disciplinary action that's been taken against you prior to the disclosure of disability and the need for accommodation, simply disclosing disability doesn't make those prior disciplinary actions go away. So does the employer need to grant Michael's request to take leave off as a reasonable accommodation and enter a rehab program? Yes, he does. Unless the employer can prove that Michael's absence would cause a great difficulty or expense to the business. This is called, under the law, undue hardship. Here's another scenario. Here's Julie. She's been in recovery for 5 years from addiction to OxyContin. In this case, Julie is under medically assisted treatment, MAT, for opioid abuse disorders, which means that she is taking methadone or Suboxone to treat her disability. She works in the office of daycare, and her boss learns that she has a former addiction. And the boss says, "Get off the methadone or you're going to be fired." In this case, does Julie have protection under the ADA? Well, in this case, individuals who are receiving treatment for opioid use disorder are generally considered to have a disability under the ADA. Methadone is a legally prescribed medication used to treat addiction, just the same as insulin might be prescribed to somebody to treat for someone to treat their diabetes. Being in medical assisted treatment for addiction is evidence of rehabilitation and that someone is not currently using drugs. So Julie's boss, incorrectly considering that methadone would be an illegal drug, would be a violation of the law. Keep in mind that Julie is under the treatment of a doctor taking a prescribed medication. Now, here's a twist. What if Julie's employer found out that she recently used cocaine while in MAT? Does Julie have rights now? No. Julie no longer has protection under the ADA because, again, the ADA does not protect people who are currently engaging in the illegal use of drugs. So discovering that Julie was using cocaine would erase those protections under the law. Here's another twist. What if Julie's employer found out that she was using marijuana while in MAT? Does she have protection? This is going to get really difficult. Marijuana in any form is still considered to be a Schedule I drug under federal law. Even if you have a card or a certificate or you have a medical prescription. You know, a former drug addict may be protected under the ADA because the addiction may be considered a substantially limited impairment. But remember that the EEOC technical guidance says that a casual drug user does not have protection. So if you are casually using cannabis or marijuana, you do not have protection under the law because of the federal, the standing of the federal law. Now, what about medical marijuana in state law? If medical marijuana is legal under state law, an employer may, and again, this is going to get very confusing, an employer may need to consider a reasonable accommodation for off-site medical marijuana use. However, an employee who is high in the workplace has no protection under federal law. And so this gets even more confusing because cannabis presents a real dilemma for employers. There are 37 states that have legalized medical marijuana laws, 18 states that permit recreational use. But we need to keep in mind that cannabis is still considered a Schedule I drug under the Controlled Substance Act of 1970. So the ADA would exclude protection from people because they are using cannabis, even if they have a prescription. The drug is still considered illegal. But even then, this issue is not so black and white. 17 states have prohibited discrimination against medical cannabis users, and 6 states have prohibited discrimination and protect the rights of recreational users. Additionally, in May of this year, Attorney General Merrick Garland reiterated that the Department of Justice is not prioritizing prosecution for cannabis use. And this reinforces a 2013 what's called the Cole Memo, which was issued by Deputy Attorney General James Cole. And in that memo, Cole said that the DOJ would not prioritize prosecution in states that had regulated cannabis distribution systems. We need to remember that it's even more confusing because the Cole Memo had been rescinded in 2018 when Attorney General Jeff Sessions advised that federal prosecutors would decide under what circumstance they would prosecute marijuana cases. So again, this is a very confusing topic, and without clear guidance, employers do need to consider reasonable accommodation for off-premises use in states where cannabis is legal. But again, we need to reiterate that employers have that duty of care to ensure a safe workplace, and employees who are under the influence of cannabis on the job have no protection in the workplace. Let's look at another scenario. So here's Juan, and Juan is addicted to Percocet while taking the medication in a prescribed manner and in the proper prescribed amount. So here Juan is taking Percocet for chronic pain. He's under the care of the doctor, but he has become addicted to the medication. Does Juan have protection under the ADA? Yes, he does, because James is protected because he is legally using drugs. Now, keep in mind, if Juan starts taking more than the prescribed amount, he may not be covered under the ADA. So Juan goes to his employer and says, look, I need to take a leave of absence. I need to taper off the Percocet because I'm concerned that I have become addicted to it. In this scenario, does Juan have protection under the ADA? Yeah, he does, because he is a person with a disability and may have rights to that accommodation to take off work, unless it presents an undue hardship for the employer. And James does have the right to talk with his employer about this accommodation, and the employer has a right to engage in the interactive process to find an accommodation that would work for Juan. Excuse me. Now, what if Juan's employer found out he was using heroin? Now, does Juan have rights under the law? No. James or Juan is not protected under the ADA because, again, heroin is a Schedule I narcotic. It is an illegal drug, and the employer has an obligation to have a drug-free workplace. However, the ADA does not limit the employer's ability to offer a leave of absence to enable one to receive treatment. We need to keep in mind, we often see what are called last chance agreements that employers might put in place for someone who has an addiction, which says that, look, I'm going to offer this last chance agreement. You need to enter into treatment and you need to seek help. And that rather than being fired, we'll enter into this last chance agreement, and I will agree not to terminate you in exchange for you receiving that treatment. But keep in mind that if you violate this agreement, or if you don't successfully complete that treatment program, then you will be terminated immediately, and because you violated conditions for continued employment. So here's some resources for you, and this will be provided to you as well. The ADA Addiction and Recovery Fact Sheet from the ADA National Network. Here's another, the ADA Addiction Recovery for State and Local Government Fact Sheet. Again, that is a publication of the ADA National Network. The ADA Addiction and Recovery and Employment Fact Sheet. The Reasonable Accommodation in the Workplace, Work, Leave, the ADA and the Family Medical Leave Act is another good resource for you. Here's some other resources that are specific to the Southeast ADA Center. We have a podcast, it's called ADA Live, that we produce every month. Episode 67, that episode was on opioid addiction in the ADA. Episode 68, opioid addiction in the ADA, with representatives from the Department of Justice. And then we also have resource lists that accompany every ADA Live episode. So along with episode 67, you can find a resource list on opioid addiction in the ADA. Here are also some resources from the EEOC, the Equal Employment Opportunity Commission, reasonable accommodation and undue hardship under the ADA, pre-employment disability-related questions and medical examinations, disability-related inquiries and medical exams of employees under the ADA. Some others, the ADA applying performance and conduct standards to employees with disabilities, employer-provided leave in the ADA, questions and answers about the association provision of the Americans with Disabilities Act. And we really have not talked about that in this presentation, but if you have an association with somebody who might have a substance abuse disorder or might have alcohol addiction, and you believe that an employer took an adverse employment action against you because of that association, and it doesn't have to be a family association, it could be a friend, you may have protection under the association provision of the ADA. Some others, the use of codeine, oxycodone, and other opioids, information for employees, how healthcare providers can help current and former patients who have used opioids stay employed. Jan has a number of resources, the Job Accommodation Network homepage, accommodations and compliance for alcoholism, accommodation and compliance for drug addiction. If you believe that you have been discriminated against in employment practice because of a substance abuse disorder or alcohol abuse disorder, it is within your right to file a charge complaint with the EEOC. And here is the phone number for doing so. It's 1-800-669-4000, or TTY is 1-800-669-6820. The ASL video phone to the EEOC is 1-844-234-5655. 5122, or you can email the EEOC at info@eeoc.gov. You might also have protection under the Department of Justice. And here's how to file an Americans with Disabilities complaint under the Department of Justice. That's web address is ada.gov/filing_complaint.htm. You can phone the DOJ at 1-800-514-0301, or their TTY number is 1-800-514-0383. And we have about 8 minutes left. So if we have questions, Jeremy, this would be a good time.
Okay, great. So for the audience to ask a question or make a comment, you can type it in the question and answer field. You can also use the raise your hand option on the menu bar that allows us to know you have a question. For those of you that may be on the phone or using keystrokes, you can use the *9 or Alt-Y to raise your hand, and then we will let you know when you are unmuted.
And while you're thinking about your questions, again, you can call your regional ADA center. That number is 1-800-949-4232. These calls are always free and they're confidential. When you call that 800 number, you'll be directed to your regional ADA center. Or you can also email us at adata.org/email, or at our web address that for the national network is adata.org. And here is a map of the various regional centers. I did that good of a job of explaining this, huh?
Yeah, I'm trying to think of my own question just to throw something and get it started.
Well, it's very complex, and certainly cannabis laws just make it even more confusing.
We do have a question.
Yes, sir.
From Youth Lead NC. Why are people who are abusing alcohol protected under the ADA, but not people who are currently using other drugs?
That is a very good question, and you would have to go back to when the ADA was signed in 1990 and what the current culture looked like at that time. That alcoholism was seen differently than illegal drug use. Remember that in 1990, we are still in the throes of Reagan's war on drugs. Really, we've evolved in our thinking, certainly since 1990, but you have to put it in a historical context.
Thank you. I think you do bring up a very good point with different states having different laws around medical and recreational use of marijuana. It does create a very complex structure. That's just a general comment.
It does, and keep in mind that it is even more complex for those border states that do not have recreational or medical laws on the books. So I was working in North Carolina last week, and I did the same presentation, and somebody said, well, here's the issue. Cannabis is legal in Virginia, but people come over the state lines to work in North Carolina. What sort do those protections then follow that person, even though they are a Virginia resident and working in North Carolina? And again, without any clear guidance from Congress on national marijuana policy or law, all that we can rely on is the fact that the Controlled Substance Act still considers marijuana a Schedule I narcotic. Other questions? We've got about 3 minutes.
I see something in the chat from Kimberly Tussaud. I'm intrigued how cannabis accommodation policies would come into play with Centers for Independent Living staff. Given I could see cannabis helping several of our staff, I'm in South Carolina and we aren't there yet, but it's something to think about in the future. I could see modified schedules.
So I assume you're talking about medical marijuana use, Kimberly, rather than recreational. And, really, you raise a very good point, because, and I do have permission to disclose, I have a member of my staff has a mental illness, right? And she takes some pretty significant psychotropic medication first thing in the morning. So we have had to make reasonable accommodation because she doesn't function well at 9 a.m., right? But at 10:30, after after she's taken her medication, then she's ready to go to work. Now, does that mean that she leaves at 5 o'clock when everybody else leaves? And no, she doesn't. Then, we've adjusted her schedule. She still has to work her entire workday. We've just shifted it to accommodate the medication that she is on. So that the same would be true, I believe, for someone with using medical marijuana, that you would then need to look at accommodations for that individual. But again, Kimberly, without some national policy, this is all very mired. And I'm glad you're in the audience.
And some comments in the chat. Great information. Thank you. Thank you for sharing this important information. Thank you for this presentation. It was very informative. As always, great job and thank you.
Well, thank you all. I'm glad that you could join me this afternoon again. So sorry we couldn't do this in person, but thanks for being here, and I hope to see you soon.
And again, thank you all. Please remember, at the close of this, when the webinar closes, there will be an evaluation that comes up. So please take the time to complete that. The organization really relies on that feedback, and it helps us make decisions about trainings and make sure that we get the most useful information for you. So thank you all. Barry, thank you very much. ASL, CART, and interpreting, thank you all very much as well.
Yep, thanks everybody. Have a great afternoon.